Welcome to Real Estate Investing Abundance, the show for busy, fulfilled professionals like you to learn how to develop financial independence built on solid, passive real estate investments. Now, here is your host, Dr. Alan Lomax.
Hello, enlightened investors. Delighted to be back with you today. I'm your host, Dr. Alan. And today we are going to take a look at a very important part of real estate, and that is raising capital without the fear of getting into trouble with the Security Exchange Commission. Our guest today, Nic McGrue, is the founding attorney of Polymath Legal, and Polymath Legal helps real estate investors fully raise capital to create generational wealth. So, Nic, take us into the show and share a memorable experience that may have helped you to be who you are today.
Yeah, if I'm thinking, early in my early formative years, kind of what got me my entrepreneurial bug is this is probably not even something that I specifically remember, but I remember my parents have told me about it. When my little sister was born, I was about 5 years old. And I think in preschool or something, we had just made our own candy. And so when my little sister was born, somebody brought candy with wrappers and said, congratulations, it's the girl. And I was going around collecting all the wrappers because I was like, I'm going to make some more candy and I'm going to resell it in these little wrappers. So early on, even though I didn't necessarily think about it as entrepreneurial at that time, I'm looking back and hearing stories when I was younger. I think early on I had that entrepreneurial bug. And that's one of the stories that my parents have told me that I had early on.
Cool. I'll bet the health department would have loved to hear about that.
Yes.
Well, things that kids can get away with. Well, a tremendously wonderful experience there. Well, Nic, first of all, I think many of our viewers and listeners know about the Security and Exchange Commission, and most probably know about securities, but give us the legal definition and understanding of what securities are.
Yeah, so with securities, for those that know or have looked into it, you're probably like, it's very confusing. There's lots of gray area, and I would agree with that. But one area where they have made it a bit more clear for us is defining what a security is. And so we learn what a security is through what's called the Howey test, Howey. This comes from a Supreme Court case that's many years old, but still is good law today. And the Howey test says that if we have an investment of money into a common enterprise with an expectation of profit, primarily from the work of someone else, then that means that we're selling a security. And so an investment of money into a common enterprise, an expectation of profit, primarily from the work of someone else, you're selling a security. So if we think about it, essentially, if we have multiple passive investors investing into the same project, we're likely selling a security. And so if we are selling a security, we either have to register that security or have an exemption for registration.
Well, an interesting definition, a bit confusing in and of itself. But anyway, what you say is if we have multiple investors investing with us, we are probably selling a security. What if we have two investors? Could that still be a security, or does it need to be over 3 or 4, or does the number matter, or is there something really more concrete about a security?
The number doesn't matter so much, but the number somewhat comes into play because part of the definition says that we're investing into a common enterprise. And so if we have one single investor, it's not always not going to be security, but it's going to be more likely that it might lean toward outside of the security realm. But definitely if we have multiple investors and they're passive, so they're relying on you to make a return on their profits, then that's almost 100% of the time going to get us into the security realm.
So if it were just 3 or 4, maybe even 5 partners who are active in the enterprise, perhaps may not be a security?
Correct, yeah. So that gets into the part where they're expecting a profit primarily from the work of someone else. And so if they're active, they're expecting a profit from the work of themselves. There probably will be others' work that also helps give a profit, but if it's not primarily from the work of someone else and they're active, then that's likely going to be the case. And so that, again, would take us outside of the security realm in most situations.
But it sounds like a fairly gray area. Is that right?
As I said before, yes, a lot of this is gray. This one, they at least gave us kind of some bullet points that we can go through and try to check off. But yeah, depending on the situation, we can still probably find some gray areas in that as well still.
Yeah. Okay. Well, what kinds of investors are typically investing in securities?
Well, it can be numerous types of investors. Since the Jobs Act, they actually opened up quite a bit of opportunities. Before, you were limited to people that essentially had high net worth or high income. With the Jobs Act, it created some additional exemptions and then changed some of the rules for current exemptions to where there are some opportunities for almost anybody to invest. Now, if we're talking about real estate, one of the more common exemptions that real estate operators use is Regulation D. And so within that, and we can probably get into that a little bit later, but within that, we look at the types of investors that are going to be investing, and that helps us determine which subsets of Regulation D we're able to use. And so within Regulation D, there's two types of investors that it's mainly focused on. The first type is what's called an accredited investor. And there's lots of different ways to become accredited, but the two common ways are through your income or your net worth. And so simply put, for income, if you made $200,000 or more for the past 2 years, and you expect to make that much or more this year, then you would qualify as an accredited investor based upon your income. If you're trying to go based upon net worth, then we're looking at somebody who has a net worth of $1 million or more, excluding their primary residence. So with many people, their biggest asset is likely the home that they live in if they own that. We take that out of the equation and we say, okay, if we take your primary residence out of the equation, are you still worth $1 million or more? If so, then you can qualify as an accredited investor based upon your net worth. So that's accredited investors. And then the other side of that within Regulation D is sophisticated investors. This one is very, very gray and very unclear, but we'll try to at least make some sense of it. So with a sophisticated investor, we're looking at somebody who has experience investing, or maybe a financial education background, or maybe has current alternative types of investments, or maybe has a financial planner. And so essentially what we're looking at is we're saying, okay, this person's not accredited, but do they possess the resources to determine the merits and risks of this investment for themselves? So if you have a financial planner, they're going to be somebody who's likely very well versed in this sort of stuff, and so they could assist. Or if you maybe have a finance background and you work in private equity, you're probably going to be able to understand how these deals work and be able to vet that as well. Or it could be a combination of multiple of those areas. So that one is definitely, like I said, very, very gray. Whereas accredited investor is pretty clear. Sophisticated investor there's a lot more wiggle room with that one.
So there's Reg D that came into effect with the Jobs Act. And so take us deeper into this. What other kinds of securities are there?
There's lots of different exemptions. So securities are just, like we said, basically the passive investment vehicles. Regarding exemptions from registration for those securities, Regulation D, like I said, is one of the more common ones with real estate operators. One of the reasons that real estate operators often like it is that it can be set up and you can get raising your capital fairly quickly. Particularly, there's no specific qualification of your offering that's required with Regulation D. So essentially, you have someone like me or another seasoned securities attorney that looks at your situation, gets you the right documents, sets up your structure, and once that's ready to go, you can start raising capital. And you just have all that in case the SEC says, hey, show me how you qualify for this exemption. You'll have all the things that you need, and you can still keep on going. Whereas if we look at some other exemption options that you have, such as Regulation A and Regulation CF, Regulation CF stands for crowdfund. Those ones require that the SEC qualifies your offering, meaning that you're still going to work with your securities attorney and get all your documents and disclosures and everything in place. Then you've got to send that to the SEC, and they're going to review it to make sure that it checks off all the boxes that they need. And if they have questions, they're going to reach out to you and you'll have to respond. And so your timeline for that process is going to be much longer than a Regulation D. And then with that, there are also additional exemptions as well. Regulation S is one. There is section 483 is another one. But like I said, regulation for real estate, I like Reg D a lot. Second to that, I like Regulation CF.
Regulation CF. So that is for crowdfunding. And I have seen more and more of these, but I don't know. I don't know how many actual real estate syndicators are actually using that CF. Many of them are certainly using that Regulation D. And so the Regulation D is real estate investors who are syndicating like that, because that particular exemption seems to clear up the gray area of the non-accredited investor. And I actually haven't seen too many offerings that are actually inviting sophisticated investors in. I don't know how many are actually using it. They actually don't put that out as an invitation. But more and more, I am seeing fewer and fewer opportunities for non-accredited investors. Can you talk to, do you know why that is? What I am told is because it opens the investor up to more liability and uncertainty, I guess, with unaccredited investors than with accredited investors.
Yeah, I can talk on that. And I think that a lot of it just comes with the exemptions that would allow you to have those unaccredited investors. So as I mentioned before, Regulation D is the exemption that a lot of real estate operators use. Within Regulation D, there's two subparts that are very commonly used. There's 506C as in cat, and 506B as in boy. So I'd say probably one of the big reasons why you specifically are seeing ones that are targeting accredited investors is that Regulation D 506C, you're only allowed to have accredited investors, but with that, you're allowed to do general solicitation. So you can advertise your deal with a 506C deal. But again, all of your investors must be accredited. Whereas with a 506B deal, you can have up to 35 sophisticated investors and an unlimited number of accredited investors, but you must have a pre-existing substantial relationship with all of those investors. So you can't advertise it. Essentially, you've got to know all of the investors that are investing into this deal. And so obviously, if we're looking at like an email list that's blasting out a deal to a large group of people, that deal has to be a 506C, and meaning that it's targeting only accredited investors. And so one of the reasons that in my anecdotal experience as to why clients like 506C more is that particularly if they have a strong network or investor list of accredited investors, they can get all of those people, plus those investors can send it to their accredited friends, and the issuer can also just advertise that deal. And so you're able to potentially cast your net quite a bit wider than you would be able to with a 506B deal. Unless you have a very large contact list of people who you do have that pre-existing substantial relationship with, you're going to be much more limited into who you can even present your deal to with a 506B versus a 506C. So that's kind of why I would say it's that general solicitation ability with a 506C. That's why you're seeing a lot of accredited only versus some sophisticated ones as well.
What are the top three legal mistakes that capital raisers typically make and get themselves into hot water with?
Yeah, so I'd say number one is being afraid of being extremely transparent and disclosing everything. If we think about this, these are private offerings. They're not publicly registered. Whereas if we're looking at a publicly registered company, we can go and see what the CEO makes. We can see what some of their expenses are and how they're paying employees and all of that sort of stuff. So we can see where all the money's going, and they're required to just disclose quite a bit of information. With a private offering, there's not going to be that quite level of information disclosure available, but you are still required to disclose certain things, particularly those things that an investor would need to know for them to determine whether this deal makes sense for them or not. And so whichever exemption you're using, you're going to have some sort of disclosure document. And I always tell clients, I say, look, this is not meant to sell your deal. If anything, it's going to scare people away, and be okay with that. Because it's going to say, the sky is going to fall, the world could end, you could lose all your money, but they'll send me your money anyway and invest. So there are going to be some kind of scary things in there. And, sometimes I'll have clients that say, hey, can we take this out? This seems very scary. And for me, that makes me want to even highlight it even more. Because I say, look, no deal is going to be perfect. Everybody knows that these deals do indeed have risks. And so if there's something where you're like, ooh, I really don't want to tell people about this because I'm afraid about it, I say we need to highlight that. We need to shout it from the rooftops, because the worst thing that could happen is that there's this risk that you know about and you choose not to disclose it. And then that risk actually comes to fruition, and now your investors are upset. And if they find out that you actually knew this was a possibility, then and they complained to the SEC, now you're going to have some issues because you essentially were hiding things. So don't be afraid of disclosing. And if anything, you want to over disclose. The SEC probably views these disclosure documents as a way to protect the investors. I actually look at it as a way to protect my clients. So that if we are telling you, hey, here's this bad thing that could happen, if that bad thing ultimately happens and an investor's upset and they say, why didn't you tell me about this? Or I'm going to sue you, or I'm going to complain to the SEC. You can say, wait, no, I did tell you about this. Look, you signed right here acknowledging that I told you about this thing. So I'd say one of the biggest ones is being afraid of disclosing or thinking, it's going to kill my deal or what have you. I always tell investors or clients, you'd rather have an investor be scared away while you don't have their money versus to have that bad thing happen and you have their money and now you've got yourself a really, really big problem. So yeah, number one, I'd say is being afraid of disclosure. Number two, I'd say is probably not knowing all of the ins and outs of your deal, particularly with your numbers. You're going to have a team around you, hopefully, but they are there to do kind of their specialized things. And I've had some newer syndicators come to me and say, what should I have my returns be? Or what types of fees should I take? And I say, I have no idea. If you're coming to me for finance tips, you are doing the wrong thing. I got the legal stuff down pretty well, but I can see when some, pro formas just look way out of whack, but I am not the finance guy. And so you want to make sure that you know the ins and outs of your deals. And if there's parts or areas that you need assistance with, you want to make sure that you are having experts in that specific field assist you and not people that are kind of generally understand it. Because like I said, I can handle the legal stuff very, very well. I'm an expert in that area, but with finances, I can look at it. I can see if it looks really funny, but I can't get into the nitty gritty of it all. And so you want to make sure that you've got your deal and particularly your numbers down pat and understanding them, because that's part of what your job is. And so the third one kind of leads into what I already talked, or I kind of hinted at it, is I'd say the third one is you got to have a team. This is a team effort here. It's a lot of work, particularly if you think about it, as you start raising capital, that in and of itself is its own job. You might be a great real estate operator and finding assets and able to rehab them and, bring their value up and that sort of stuff. That's one job. Raising capital and working with investors is another job in and of itself. And in addition to that, you've got to do the legal compliance, you've got to have accountants and other things. So you really do want to make sure that you have a team around you, because that's going to make your life easier and also just going to likely increase the opportunity for success with that project.
Well, Nic, share with us one of the biggest disasters that you have experienced with your clients.
So I can say, thankfully, this was not a disaster with my specific clients. But with us, we a lot of times will we'll do informational meetings with potential clients that may have a deal coming in the future and want to get to know us. And so I remember probably about 3 or 4 years ago, we had been taking on a lot of informational meetings and had people that said, we'll talk with you when we have a deal. We said, great. Then there's about a period of maybe 2 or 3 days where I got probably 5 to 10 phone calls or emails with people saying, the SEC sent me this letter. They said that I can't delete anything. Basically, it was what's called a litigation hold. Whether it's dealing with the SEC or any type of litigation, if there's documents involved, if you get a litigation hold, it basically says, hey, there's a potential lawsuit going on that you might be somehow, some way involved with, and you might have some documents that could be helpful to us. So don't delete anything.
Right.
And so they were not clients at that time. Some of them later did become clients, but they got those litigation holds and they're saying, what's going on? I'm so afraid. What's happening? And I said, well, we don't know what's going on. The SEC just thinks that you might have some sort of document. And so don't delete the things that they told you not to delete. But what was happening is that there were, the SEC was investigating people taking unlawful finder's fees. So this is one area, I wouldn't say it's one of the biggest areas where people mess up, but this is one area where people may have blinders on. And also I will candidly say the setup of the law right now, I think is bad and makes no sense. So if you are going to pay somebody a finder's fee, meaning that they're, introducing you to potential investors, it has to be truly a finder's fee. It can't be a commission, or it can't be what the SEC calls a transaction-based compensation. And so what that means is that if I'm going to pay you a finder's fee, And if I say maybe I'll pay you $500 for everybody that you invest or that you introduce me to that might be a potential investor. If we come to that agreement, I've got to pay you that $500 per investor, regardless if they make an investment or regardless of how much of an investment they make. I am paying you solely for the introduction. If I'm paying you only when they make an investment, or if I say I'll pay you $500 for any investment that's $20,000 up to $20,000 and $1,000 for anything above that, that's going to make it a transaction-based compensation. And unless you are a licensed broker-dealer, you can't do that. And so there was some issuer that essentially was paying these types of finder's fees that weren't actually finder's fees, and the SEC was looking into it. Thankfully, all of those potential clients, the ones that became clients and the ones that didn't, the SEC wasn't specifically looking for them. So thankfully, from what I've heard, all of them fared out fine with that. But yeah, that was at least a bit of a scare, even for me. And again, they weren't my clients, but I thought, oh no, this is not good. I don't want anybody to have to be bad. So it's a bit of a scare, but thankfully, from what I can recall and what I've heard, they all came out unscathed.
Well, this litigation hold that prevents them from destroying any documents, does it inhibit any of their other business activities and transactions?
Not just by the litigation hold, no. The litigation hold just says, we think you might have some documents that are the subject of litigation, so don't delete them. And until there's any other action taken and any orders or judgments rendered, it wouldn't preclude any future action or current action of those people at the time.
Well, Nic, share with us what you have to offer in terms of offering security legal advice and other things that real estate investors may be interested in.
Yeah. Like you said at the beginning, Polymath Legal helps real estate investors lawfully raise their capital so they can build generational wealth. And so with that, we do lots of syndications and different types of funds. And so we have, for the most part, we charge flat rates for our packages, and we have packages for Regulation D syndications, Regulation crowdfund offerings, as well as Regulation A offerings. In addition to that, we create entities. We both review and draft contracts and handle many types of transactional legal matters as well. And as you said before, we also are here to advise and assist clients as they're structuring things and answer questions that they may have as well.
Do you offer those services nationwide?
Yes. So that's one of the cool things about this specific area of law is that we are dealing with federal security law exemptions. And so with that, we do have clients not all over the country, but definitely outside of California where we're located, because we're handling federal law and not any individual state-specific laws.
Okay. Well, great. Well, viewers and listeners, thank you so much for being with us today. Been an informative and delightful conversation. And Nic, thank you so much for being with us today.
Thank you so much for having me. It's been such a pleasure. And like I said, I echo the sentiments of very delightful and great conversation.
Thank you for tuning in to Real Estate Investing Abundance, brought to you by Steve Talker Capital, a company working for passionate professionals like you to develop financial independence built on solid, passive real estate investments. As part of our efforts to make the world a better place, Steve Talker Capital contributes to activities and organizations committed to better understand the equine. These endeavors attempt to enhance the human treatment of horses worldwide. Steve Talker Capital, working for a world where all creatures, great and small, flourish abundantly. For resources to develop your financial independence, connect with us at stevetalker.com.